the ALR and why it's important. When people are arrested for driving-related offenses, such as a DWI, they often focus solely on their criminal court case. However, there's another critical proceeding that's equally important. The Department of Public Safety DPS hearing, also known in Texas as the Administrative License Revocation Hearing, or ALR. This hearing isn't about determining guilt or innocence in a criminal sense. It's about whether you'll keep your driving privileges. Many people underestimate the significance of this hearing, which can have immediate and long-term consequences for your ability to drive. I sometimes hear that people are told it's a waste of time and money. This is the farthest thing from the truth if you've been arrested for a DWI offense. As a practicing criminal lawyer for nearly 20 years, I'm here to explain why the ALR hearing matters, how it differs from your criminal case, and why handling it correctly is essential for protecting your future. What is an ALR hearing? The ALR hearing is an administrative proceeding. Its purpose is to determine whether your driver's license will be suspended or revoked due to an arrest involving alcohol or a drug-related driving offense. So how is it different from the criminal matter? The ALR hearing is completely separate from the criminal court case. Winning one doesn't guarantee success in the other. There's a clearer focus on driving privileges in the ALR hearing. The ALR hearing only addresses your right to drive, not whether you're guilty of a crime. There's a lower burden of proof. The standard of proof in an ALR hearing is lower than in criminal courts. The state only needs to show, by preponderance of the evidence, meaning it's more likely than not that a violation occurred. So why does it matter? While it may seem like just a bureaucratic step, the ALR hearing from the State Office of Administrative Hearings plays a pivotal role in your case and your life. Here's why. Number one, immediate consequences for your license. If you fail to request a hearing within 15 days of receiving your suspension notice, I personally count the date of arrest as day one, just to be safe. Your license will be automatically suspended. The durations can range from 90 days, depending on the offense and whether you refused a chemical test. It's also an early opportunity to challenge the evidence in your criminal matter. The ALR hearing allows your attorney to review and challenge the evidence against you early in the process. This includes examining whether the officer had reasonable suspicion to stop you or probable cause to arrest you. Also, your lawyer can question the accuracy of field sobriety or chemical tests. There are strategic benefits for your criminal case to have an ALR hearing. What happens during the ALR hearing can influence your criminal court defense. There's the possibility of the discovery of evidence. Your attorney can gather information during the hearing that may be used to weaken the prosecution's case in criminal court. This is one of the only times related to a criminal case where the defense attorney can take the equivalent of a deposition of a witness. The ALR hearing provides a chance to question the arresting officer under oath, potentially exposing inconsistencies or procedural errors before the officer has met with the criminal case prosecutor to get what is called woodshedded or prepared to testify. There are some common issues that can be addressed in an ALR hearing, such as the validity of the stop. Did the officer have reasonable suspicion to pull you over or probable cause to arrest you and request a chemical specimen? Did you refuse a chemical test? And was the refusal handled according to proper procedures? Was the breathalyzer or blood test properly administered and calibrated? Did the officer follow the required protocols during the arrest and testing process? What happens if you lose the ALR hearing? If the hearing officer from the State Office of Administrative Hearings rules against you and in favor of DPS, your license will be suspended. However, this doesn't mean you're out of options. You can apply for what's called an occupational license potentially. You may be eligible to apply for a restricted driver's license that allows you to drive to work, school, or other essential appointments. After the suspension period, you'll need to meet specific requirements such as paying a reinstatement fee, providing proof of SR-22, which is also known as high-risk insurance, completing a DWI education course if applicable. So why do you need an attorney for the ALR hearing? Many people think they can handle the ALR hearing on their own or skip it altogether. This is a critical mistake. The ALR hearing is not just a formality. It is a key opportunity to protect your driving privileges and strengthen your overall defense. An attorney can help with the filing of the hearing request, ensuring that you meet the 15-day deadline to avoid automatic suspension. If you do nothing, your license will be suspended. You have nothing to lose by having the hearing. Challenge evidence. Attorneys know how to question the validity of chemical tests, traffic stops, and officer testimony. A skilled lawyer can use insights from the ALR hearing to further build a stronger case in criminal court. Take control of your driving future. Ignoring or mishandling your ALR hearing can result in a loss of driving privileges, higher insurance rates, and a harder road ahead in your criminal case. So make sure you contact a criminal defense attorney as soon as possible. Thank you.